Advocacy of the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. I've been previously introduced. My name is Rand Wallace. I'll be presiding over this case and these cases, and I have joining me on the panel Judge Paige Kilbane to my right and your left, and Judge Jordan Pratt to my left and your right. We have two cases that are traveling together. It's Florida Farm Bureau General Insurance Company versus Linda Williams, and same appellant versus Richard Jones and Nancy Jones. First, if anybody has any device that makes noise, phone, iPad, computer, or anything like that, please put that on mute or just more easily turn it off so it doesn't disrupt the parties when they're making their presentation. Because we have two cases traveling together and the fact patterns are almost virtually identical, there's a little bit of variety, but not a whole lot. I would propose 30 minutes for each side for a presentation, unless the parties object to that. We have for the appellant, and I may butcher your last name, Lalu Amani, is that correct?
Lalu Amani.
Okay, I did really poorly with that. Okay.
No problem.
Any objection to the 30 minutes?
No, I think that's fine.
Okay.
Thank you very much.
And I will assume 5 minutes for rebuttal unless you tell me differently.
That works perfectly.
Okay, and then Mr. Stedman, that's a little easier. So any objection to the 30 minutes?
No objection, Your Honor.
Okay, so I will adjust the time, and then the appellant may proceed when you're ready.
Thank you, Your Honor. Good morning, and may it please the court. Sarah Lalu Amin on behalf of the appellant, Florida Farm Bureau. I'd like to thank the court first for consolidating these matters for purposes of oral argument so that they can travel together. We know that this is an important issue with widespread impact. It's affecting these two cases. There's other cases in the pipeline that we've notified the court of by notice, and there are more to come if the plaintiff's two-step analysis is adopted by the court as it was by the trial court. So with respect to that two-step analysis, I'll jump right in. The plaintiffs ask this court to adopt this analysis whereby the first step is a determination of the period in which a hurricane deductible applies, triggered by the date of loss, and running through 72 hours following termination of the last hurricane watch or warning. And then the second step they would propose is that the court determine, based on evidence, whether the loss was caused by a hurricane. There's no foundation in the policy or the statute for this approach. It's contrary to the legislative intent, and practically, as we've discussed in our briefing, it just doesn't work. And so for these reasons, we ask that the court reverse.
Ms. Lalu Amin, can I first ask you, taking them in reverse order, I guess, from what you just mentioned, the statute, can you clarify your position on the relevance of the statute to this case? What we should be consulting the statute for? Is it simply background information about the likely meaning of the terms as used in the policy, or is it your view that the statute requires the policy to contain certain terms, or that it provides a default? And if so, where is the operative provision in the statute that actually does that?
Absolutely. Thank you, Your Honor. And in this case, the statute and the policy are consistent. And so the relevance of the statute is to inform the application of the policy language, to inform the terms, for example, the definition of windstorm, but that's undisputed here. This case involves a hailstorm, and it's undisputed that by the parties that that does constitute a windstorm. The trial court actually exhibited some confusion in that regard initially, likely persuaded by the plaintiff's expert, who proposed that a hailstorm really can't ever be caused by a hurricane. And so that's one of the practical problems we see here, and the foreshadowing of what's to come is if we allow causation on these questions, it's plainly contrary to the language of the policy. And so going to the statute, I'll walk through the relevant provisions there. So the statute expressly states that hurricane, for purposes of paragraphs A and B is the definition of windstorm. And then it defines hurricane temporally. It defines hurricane as the duration of a hurricane includes the time period in Florida beginning at the time when a watch or warning is issued and running through 72 hours.
Question about that. How is that consistent with the policy? Because the policy doesn't include the temporal definition within the term hurricane. It includes it within the term hurricane occurrence, right?
Yes.
So it looks like it's not exactly tracking the statute. Is that fair?
That's fair, because the policy provides, the policy endorsement that we're construing is an endorsement for the application of a hurricane deductible. Whereas the statute, and this gets back to your question, Your Honor, about the relevance of the statute is actually talking about hurricane coverage. And so it's a slightly different context, but the terms are the same. The terms are consistent. And so flipping back to the policy, the analysis is similar. So the policy is triggered by a loss. If we look at paragraph D of the policy endorsement, it's at page 143 of the record, of the Williams record. So D tells us, in the event of a first windstorm loss caused by a single hurricane occurrence during a calendar year. So that's where we begin. And windstorm loss, I want to emphasize that, because there's this concern raised here that we're insisting on causation by a duration. And that's not the case. The policy plainly starts the analysis, causation by a windstorm loss.
Well, counsel, why are we starting our analysis, looking at the endorsement, why are we starting our analysis at section D? Wouldn't we look at section A? And in section A, with respect to paragraphs C and D, coverage for loss caused by the peril of windstorm during a hurricane, which occurs anywhere in the state of Florida. So that term doesn't use hurricane. Or hurricane occurrence. The only place that a hurricane occurrence appears, I believe, is in section D. Is that correct?
Yes, so section D is the triggering event, so it talks about the windstorm loss. Section A actually gets into interior damage, and so it specifies the application of the deductible to certain interior damage. And so it's not really where the windstorm loss, where the analysis begins. The analysis begins in D, but A is consistent. And I appreciate the reference to A because, again, it's speaking in terms of duration. It's speaking in temporal terms. Caused by the peril of windstorm. Check. We have causation by a windstorm here. That's undisputed.
During a hurricane.
During a hurricane, precisely. During that period that is statutorily and policy contractually defined as the time when the watch or warning goes into effect through 72 hours after its termination. It's undisputed that we are within that time period here.
Ms. Lalou-Lamine, can I ask you about your reading of a particular statement in subsection C? I understand that the parties briefed A and D. But subsection C provides, and the heading is calendar year hurricane deductible described. So it's describing the deductible. And it says, a hurricane deductible, and then I'm going to omit some words. A hurricane deductible applies to loss to covered property caused by one or more hurricanes during each calendar year. How would you have us construe that language? So
Your Honor, and first, of course, that's not before the court today. because we don't have a multiple deductible situation. But a large area of issue of concern in the application of hurricane deductibles is that people don't get hit with them too often, right? And so within a single calendar year, if there's more than one hurricane as statutorily and contractually defined, then this provision addresses how that works.
Okay, fair enough. Let's omit the more hurricanes language. A hurricane deductible applies to loss to covered property caused by one hurricane, caused by a hurricane. If that's describing the operation of the deductible, are you asserting an inconsistent reading of subsection D? And if so, how do we reconcile that inconsistency?
Yeah, thanks, Your Honor. No, I don't think it's inconsistent. The language of C is trying to advise policyholders, again, in plain language, how this works when we've got 2 or more hurricanes within one calendar year. And so, as we see in the plaintiff's argument, as we see in notices to policyholders by the state, there is this colloquial reference sometimes to causation by a hurricane. But when we get into the nuts and bolts of how it operates in this policy and in the state of Florida by virtue of statute by the legislature, it operates by windstorm loss during that hurricane period.
So going to subsection D, and I understand you're focusing on the language there still is the language of causation.
Yes.
Right? And it says caused by a single hurricane occurrence. So I guess the question that I would have then is how would you define the meaning of hurricane occurrence? What does hurricane occurrence mean?
So hurricane occurrence, back in section B of the same endorsement, a hurricane occurrence begins at the time a hurricane watch or warning is issued and ends 72 hours following the termination of the last hurricane watch or warning. So it is in this duration period, but it's a windstorm loss. And perhaps it would have been cumbersome to say caused by a windstorm, caused by a hurricane occurrence. Again, this is a balance, but the policy is clear and the statute is clear.
That gets it backwards because it talks about a windstorm loss caused by something. It's not saying caused by a windstorm. It's saying a windstorm loss caused by a hurricane occurrence. So I guess there are really 2 ways that one could read hurricane occurrence, right? When it says in B sub 2, right, a hurricane occurrence begins and ends, that could either be the definition, right? That could be what the term means, or it could be simply describing but not defining hurricane occurrence. So which, in your client's view, which of those is it? Is B sub 2 describing hurricane occurrence, or is it defining it?
So it's both. And so the definition of hurricane precedes the definition of hurricane occurrence. And so the definition of hurricane in Part B, hurricane described, is the title of that section. A hurricane means a storm system that has been declared to be a hurricane, and the occurrence begins and ends. And so it provides all of that information in B to apply D. And I'd also like to note, because I think it's important that we do explore the totality of this endorsement, the totality of the policy, and how it gels with the statute. And so I'd also like to point to Part E of the endorsement. So Part E of the endorsement, I think it's key, has not been relied upon by the plaintiffs here. So Part E states, loss by windstorm that is not a declared hurricane, because ultimately that's what they're asking this court to find. That's what they asked the trial court to find based on their causation evidence, based on their expert testimony. Refer to the policy declarations for the deductible that applies to windstorm loss if the circumstances of the loss described above do not apply. It does not say if the loss was not caused by a hurricane. That would have been a very simple way to say it. Simple to say, but very complicated to implement.
I have a clarifying question going back to D. So if I heard you correctly, it sounds like hurricane occurrence is temporal. It's a period of time. Is that true?
Yes.
Okay. So how can a period of time cause a loss?
I understand that, Your Honor, and a period doesn't cause a loss, but what is the causation component? The causation component is a windstorm. So this is a windstorm loss.
But it says a windstorm loss caused by a hurricane occurrence, which is a period of time, right? So, yeah, if you could unpack that for me a little more, that would be helpful.
Sure, and I thought about this, Your Honor, because, why doesn't it say caused by a windstorm? But bottom line, a windstorm loss is necessarily, everyone would understand that to mean a loss caused by a windstorm. There's no other operation of windstorm in that sentence than to understand that it has to be a loss that's ultimately caused by a windstorm. The question is whether it's a windstorm that has this relationship to a hurricane as defined in the policy, or whether it's subject to Part E, a windstorm that doesn't meet these specifics here within the endorsement.
Counsel, if we could focus again back on the hurricane occurrence, this duration, that is not found in the statute. Is that correct?
So the statute, again, because it's talking in terms of hurricane coverage as opposed to hurricane deductible, the statute doesn't use these terms exactly in the same way, because it's talking about just the availability of insurance period versus the application of a deductible. And so an occurrence is language that you see used in a policy. So occurrence is policy language. The statute, however, does speak in the same temporal terms. So the statute, and again, we're referring to the 2020 version of the statute, because the 2023 version, we provided that to the court. We provided it by way of supplemental authority, and I wanted to just very quickly speak on that for a moment. The additional materials we've provided are to demonstrate to the court that the argument, the construction here, is consistent with all of that. So it's not to rely on those additional authorities, if you will. It's simply to show that they're consistent. And so back to the language of the statute, hurricane coverage is coverage for loss or damage caused by the peril of windstorm during a hurricane.
And counsel,
Yes.
just to take you to my question here.
Yes.
So hurricane is defined almost as a specialized definition, which you referenced. So we'll say capital H hurricane in the statute. And that hurricane in the statute encompasses the temporal requirement, does it not?
It does.
But the policy does not do that. As you stated, it's two definitions.
The policy does do that by virtue of the hurricane occurrence, which is right under, so Part B, hurricane described. And Part 1 of Part B in the endorsement, page 143 of the record in Williams, a hurricane means a storm system that has been declared to be a hurricane. Part 2 says a hurricane occurrence begins and ends. And so it then tells you the duration of that hurricane. And so then going back to D, or even operating from A, as Your Honor pointed out, it's all consistent. Caused by a windstorm, check, during a hurricane. And that duration is defined. That duration, a hurricane occurrence, begins at the time and ends at the time. And so we have hurricane occurrence being used in D, described in B, and it's all consistent because the definition of a hurricane, by virtue of the policy, by virtue of the statute, includes that temporal aspect, because a hurricane is something that occurs for a period of time.
And we keep referring to the statute. I just want to make sure that I'm clear on your perspective about the relevance of the statute. Would it be a correct understanding of your position to say that the statute provides useful background about the meaning of these terms, which presumably were incorporated into the policy, but to the extent that the policy contains language that diverges from the statute, then we would construe it based on what the policy says and not based on what the statute. I understand your position is that they're in sync, they're simpatico. But if we were to read both and say they look different, then it sounds like you would agree that the language of the policy controls over the language of the statute. Is that correct?
That's correct, Your Honor. And I think the statute's relevance is especially helpful in that definition of windstorm, but again, that's undisputed here. And I do want to comment on that more specifically about the evidence that was before the trial court. So this issue is essentially about whether we can apply the policy as written or whether, and I think it's important to think about what this practically looks like, because again, simple to say, caused by a hurricane. Very simple to say. A lot of words could have been spared by both the legislature and carriers across the state and the Office of Insurance Regulation if that's all we had to say. And if that's all we said, we absolutely would be engaging in a battle of the experts every single time. We absolutely would be saying This loss was caused by a hurricane. No, it wasn't. It was a local storm system. Well, that's the evidence we have here. And
To be fair, counsel, it similarly could have been easy to say, in the event of the first windstorm loss suffered during a hurricane occurrence, right? Would it at least be fair to say that that would have been a clearer way to write, what you're having us, the way that you would have us interpret this policy? Would you at least concede that that would be a more clear way to say what you're saying that the policy says?
Your Honor, I think it might give rise to other questions and inconsistencies. I think that the Office of Insurance Regulation in approving these policies, all with very similar language, and I think the legislature, the wisdom of that language really comes to light when you think about how this plays out. And when you have to balance it with the understanding of the policyholders. So if we're talking about the context of multiple hurricanes versus the context of, okay, we have one hurricane, does the deductible apply or not? I think they're different contexts. And I think that the endorsement as a whole, and of course, when the court is construing contractual language, statutory language, it's looking at all the provisions together and making sure they gel. And key to that analysis is Part E that was never relied upon by the plaintiffs here. And so back to the evidence that was before the trial court, I want to note this language from the expert. And again, like Part E, this is, I would say, conspicuously absent from the argument, but there's evidence here that hail is never caused by a hurricane. That's what the expert testified. And so we have two components working here in terms of their causation argument. There's the component of, hey, this was after the hurricane ended. Well, yes, by very definition of the contract and by very definition of the statute. The deductible applies 72 hours from that time frame. And
right,
so
causation only comes in, it seems like, if we adopt, the different interpretive methodology of your friend on the other side, right? So, I mean, if we did that, is there any evidence in the record that would redound to your benefit, your client's benefit on causation? Is there any countervailing evidence that, this particular windstorm, this hailstorm, was actually caused by the hurricane? Or I seem to recall that there was a concession in the briefing that there was not such evidence. But is there any evidence?
That's true, Your Honor. I will concede that. And I'll be specific in my concession, however, that what we're talking about there is this self-defined notion of meteorological causation that finds no bearing in the policy, that finds no bearing in the statute. And again, easy to say, but practically, how does that look? Well, when are these deductibles applied? Hopefully not so often in litigation like in this case. Hopefully, they're applied routinely as a simple matter on the front end in the wake of natural disasters, and they're able to be applied like this. That's the design of the policy. That's the design of the statute. And if it's not applied that way, then we're forcing carriers to hire scientists on the front end of these claims in the wake of natural disasters. It's not going to be cost effective to do that. So what this two-step process does is it entirely guts the 72-hour period. It entirely renders it superfluous in practice, because in those instances, the argument, of course, can always be made, well, the hurricane's gone. This isn't caused by a hurricane.
But doesn't that interpretation, your interpretation of the policy, then renders the word causation all throughout to be meaningless?
Causation all throughout. So the causation component is the windstorm. And so the windstorm loss, that is the nature of the loss. So it was discussed, I think, at the hearings. There was a question raised, well, then I guess anything that falls within this period would be subject to the deductible. What about a pipe burst because there was a plumbing failure unrelated to the hurricane? That's not a windstorm loss. So this is a policy determination, and policy determinations we leave in the hands of the legislature. And the legislature has to reckon with what happens to Floridians, what happens to policyholders, what happens to the industry when...
It sounds like, counsel, that the legislature hasn't done that here, because when I asked you previously about the operative effect of the statute, and I may have misheard or misunderstood, but it sounds like the statute doesn't have an operative effect. It provides a definition of words, but the policy is free to vary its meaning of the words or to use different words if the insurer so chooses, which it did choose to do, at least with respect to hurricane occurrence. Is that an accurate recollection? Accurate?
Your Honor, no, and I'm sorry if I misspoke. And so the effect of the statute, it's binding law. It's incorporated into the policy, but again, it's speaking in terms of hurricane coverage as opposed to a hurricane deductible. And so the terms are different. But in terms of incorporating the statute, in terms of what is binding on the parties here, the legislature has spoken, and the policies are implemented based on that. And so that is the basis for this temporal notion. Otherwise, the Office of Insurance Regulation isn't going to be approving these policies if they're inconsistent with the statute. This is how it's meant to operate. This is how it needs to operate, or else we're injecting this process.
So the statute, though, does not define hurricane occurrence, correct?
Correct, Your Honor. An occurrence is typically something that's defined in a policy because it's talking about when something is covered or not.
So, and I understand your position to be that B sub 2 doesn't just describe hurricane occurrence, but it rather defines it, right, and defines it as a time period. If the court were to, and correct me if I misunderstood, if the court were to disagree and to say that it looks like what the policy is doing is not really defining hurricane occurrence, but just describing it, where besides the policy would we look, or would you suggest that we look, to define the term hurricane occurrence, given the fact that that term does not appear in the statute?
So if we again, the definition of windstorm, and we talked about that earlier, it's not disputed that this is a hailstorm, it's within the definition of a windstorm, but the statute refers again and kind of scoops up, if you will, just like the policy does, that language of duration, that language of causation, because Part B, defining windstorm for purposes of paragraph A, means winds, wind gusts, hail, rain, tornadoes caused by or resulting from a hurricane. Part C of the statute, hurricane, for purposes of A and B, for purposes of the windstorm definition, and then it provides that temporal duration language. And so this, Your Honors, is the only way that this can meaningfully work. Otherwise, it is an absurd result, just like the result advocated in Moody by the plaintiffs. So Moody is distinct in that it was a tornado. It was within the period of time of the hurricane. So we didn't have this 72-hour issue. But the 72-hour issue is plainly encompassed, just like tornado was, and plainly encompassed, just like hail is, although the expert disputed that as well. And so in Moody, the same two-step analysis was proposed and rejected. There, the plaintiffs argued their loss must be caused by a hurricane and not just caused during a hurricane. And that was the proposition that was rejected in Moody, and that's in the middle of page 1169 of the opinion.
Counsel, you're right into your rebuttal time.
Yes, Your Honor. So with that, unless the court has further questions, I'll reserve the remainder of my time.
Okay.
Thank you.
And Mr. Stedman, you may proceed when you're ready.
Good morning. May it please the court. I just wanted to thank the court for taking on these cases. I know that they originated in the first DCA and they were moved here, so I appreciate the time that's being given to these cases. So I think the most important point that's been discussed already by my counterpart on side of the appellants is that this is a case about causation. Causation, the language caused by comes up a lot of times in both the statute and the policy. Causation is necessarily a factual question, so it's our position that causation is something that needs to be addressed by the court when there's a question of fact. it doesn't always come up. And I think that's part of the issue in this case is that causation isn't necessarily brought up. Jumping to the Moody case, for example, the issue of causation was a completely different situation because they were discussing tornadoes that were spawned by the storm system that was in effect there. So in this case, I think that it's very important to consider the issue of causation. I just wanted to highlight a couple of the factual issues that were brought up in this case.
Before we do that, Mr. Stedman, and I wanted to get both parties' take on the relevance of the statute, because both parties discussed the statute at length in the briefing. But I'm just curious how you would have us connect the dots between the statute and this policy. Is the statute providing, background context about the default meaning of words? Does the statute affirmatively require policies to, have certain types of coverage and deductibles? And if so, where is that in the statute, or is that, are we just looking to the statute as like a useful guide about the meaning of these terms, but the policy controls? So if you could explain that, the interaction between the policy and the statute, I'd appreciate it.
Yes, Your Honor. So in some respects, we're in agreement with appellant in terms of how this applies, because I believe that the application of a hurricane deductible is a slightly different consideration than the application of hurricane coverage in general. I think that the statute is specifically talking about how insurance companies must provide insurance coverage and how that's to be applied and defined. However, we believe that the statute also, the terms that are used in the statute are definitely relevant to be considered when considering the policy language as well. I think that comes up most importantly in the word windstorm that's brought up in the statute. The word windstorm, I don't believe, is defined in the hurricane deductible endorsement that's contained in the policy. So looking to that word in the statute, it defines windstorm as wind gusts, hail, rain, tornadoes, or cyclones caused by or resulting from a hurricane. So we have another situation where the causation element is brought in by the definition of windstorm that's contained in that statute. So when we have this language in the policy talking about a windstorm that is caused by a hurricane occurrence, it's our position that this word windstorm again raises the question of causation. It's carrying within that word, which is otherwise not defined in the policy, the question of whether it was caused by a hurricane or if it was caused by some other causation. And
Counsel, if I could give you a little hypothetical, let's assume that the policy defines hurricane like the statute does, meaning that it includes that temporal requirement. Would you still be proposing this two-step analysis?
Your Honor, I think, yes, thank you. I believe that does still fall in line with what we're proposing here. Because that causation element still comes in. You've got the definition of hurricane contained in the statute, and it contains a temporal element, but it doesn't end there. You still have to consider whether the storm system that's occurring during that period is causing the damage that's happening. And as I mentioned, it's kind of rare that we run into these situations where there's even evidence that it was caused by something else. Even in Moody, the expert that was presented by the homeowners admitted that tornadoes can be spawned by storm system, and the Fourth DCA in that case came to the conclusion that the storm system spawned those tornadoes. And it wasn't really addressing the causation issue in that case, but it's nonetheless a situation where we believe that you still have to consider that caused by language to determine if it's applicable. So it raises a question of fact that I don't believe that it raises a public policy issue to the extent that's being brought up by appellant in this case. I don't think that it causes a wide-ranging set of circumstances where there's going to be thousands of homeowners claiming that that hurricane damage is not actually hurricane damage, because usually these instances are connected to the hurricane. And for example, in this language in the 72-hour period that's laid out, I believe that language is specifically applying to a situation where a hurricane has been downgraded but still causing damage. So we have situations like that in the state of Florida where a hurricane makes landfall. It's no longer defined as a hurricane, and therefore there's a question of whether it should still be considered within the hurricane deductible or in hurricane coverage.
Why is that, counsel? If the language is clear and there's been a defined term, why would there still be that causation question there? Where are you finding support for that?
Well, Your Honor, it's in the language of the statute where it talks about the causation. It includes that same caused by language. So,
And I'm sorry, my question was unclear. That was
Okay.
my fault. Talking about it's referring to a downgrade, it's referring
Oh, right.
to, where are you finding that? Because, I mean, the policy has the ability to define the term. The question is how they defined it, whether or not that's clear, things like that.
understood.
That's why I'm curious how, if the temporal requirement is included within a specialized definition, as it is in the statute, whatever its relevance, how would the causation still apply? If a windstorm occurred during that period, that there's this declared hurricane, how would causation apply at that point?
And so, again, I think that it's basically a situation where if the temporal period is important for determining whether, the first step to determining whether this coverage and this deductible would apply. So if you're within that 72-hour period after the end of the last, I believe, hurricane watch or warning. So if you're back into a situation where it's a tropical storm watch or warning, and you still have the outer bands of the hurricane, for example, occurring, but it's no longer termed a hurricane, you still could have damage being caused. A lot of these storms that have hit Florida are extremely large, so they downgrade the definition or the hurricane watch or warning down to a tropical storm, but those outer bands are still causing damage. And so coming back to that causation issue, sometimes these storms move quickly. So in a case like we're talking about in this case, I believe that the appellant's expert actually provided some opinions about how the storm system that had been termed Tropical Storm Isaias when it was over Florida was actually the outer bands were over New England at the point of time when the actual damage occurred. So that's why the causation issue is important, because we have a situation where the storm system itself undisputedly has moved out of Florida and is no longer impacting the state. We have another storm that has come in. It could be, I'm not a meteorologist, but basically a different storm system than the one that was in question. And the reason why causation is important in this consideration of the statute and the policy is because it's a completely separate storm that could be causing the damage. And so it's not a situation where the legislature conceived a downgraded storm system causing damage, but rather completely separate.
Mr. Stedman, can I get your take on hurricane occurrence? So in B sub 2, it says a hurricane occurrence begins and then ends. In your view, is that defining hurricane occurrence, or is it merely describing without defining hurricane occurrence? I guess that's the first question, and I have a follow-up based on that.
Your Honor, I would consider that a definition of hurricane occurrence. I believe that that's attempting to define that phrase.
So then it's defining it as a time period. So then when we go to D sub 1, the operative language here is in the event of the first windstorm loss caused by a single hurricane occurrence. And if hurricane occurrence just means time period, right? I'll just substitute that. In the event of the first windstorm loss caused by a single time period, what would you have the court do with that language? If that's in fact a definition, and the definition is a time period, then when you substitute that time period in for the word hurricane occurrence, you get windstorm loss caused by a time period. How can a time period cause a windstorm loss? Is that provision unintelligible? I guess is the first question. If it is, then what do we do with it? If it's not unintelligible, then how would you have us read it to be intelligible?
Your Honor, that is a good question. We touched on it briefly in the briefing of this case. I don't believe that the definition provided there could be the cause of something. A 72-hour period, the position is that a time period can't be causation. And to some extent, it would appear that section is potentially unintelligible. It hasn't been addressed heavily in the briefing because I don't believe that the question of ambiguity was really raised at the trial court level. However, I do believe that that's kind of a situation where the policy was written in a way that kind of doesn't make sense, to be honest. In that section, it's basically saying a windstorm. So the cause of damage in that case would be a windstorm, and then, no, sorry, strike that. The cause of damage is a windstorm, or the hurricane occurrence. It says caused by, a windstorm caused by a hurricane occurrence. So a purely temporal definition stating a period of time that begins and ends as defined by the policy, it wouldn't appear that that's something that could cause damage. And so that kind of brings up a point that we raised in this case, which is that the carrier has the ability to write its policy however it sees fit. And the carrier could have written this in a number of different ways, could have tracked the statutory language a little bit more closely, because as discussed, the statute talks about hurricane and kind of wraps that temporal element into the definition of the statute. And additionally, there's been some discussion of the Moody case, and again, that was a situation where the insurance company had a slightly different language in their policy. So,
and to give both sides a chance to answer, just going back to the policy language, I asked your friend on the other side about section C, right, where it's calendar year hurricane deductible described. I'm going to omit some language just for clarity here, but a hurricane deductible applies to loss to covered property caused by one or more hurricanes during each calendar year. Could you give us your perspective on that language and its impact, if any, on this case?
Yes, Your Honor. So I think that section falls in line with the position that we're taking here, which is that a question of causation is raised. The application of multiple hurricane deductibles, just as the application of one hurricane deductible, it's a question of whether the hurricane itself caused the damage in each situation where the deductible is potentially being applied. And so subsection C perhaps provides a little bit more clarity as to the intent here, which is that the damage in question actually be caused by a hurricane.
Okay. And as a follow-up to that then, how would you have us view the fact that D uses decidedly different language, right? So C says caused by a hurricane, caused by one or more hurricanes. And then D says caused by a single hurricane occurrence, right? So there's a departure from the language of C, which says caused by one or more hurricanes. And then D sub 1 is caused by a single hurricane occurrence. And then sub 2 is caused by subsequent hurricane occurrences. So we've got caused by hurricane occurrence. How do we resolve that dissonance between subsections C and D?
Your Honor, at the risk of saying that the policy could have been drafted a little bit more cleanly, I perhaps wonder that maybe that was unintentional. Perhaps the drafters of this policy intended those to be read in conjunction with each other and in line with each other, but hurricane occurrence was applied in this policy perhaps to mean the word hurricane as used in subsection C. It doesn't exactly make sense to me why they would have used a different language in those two sections, perhaps other than just a mistake even. However, even reading those two together, they still both bring in the question of causation if we're using the word windstorm, and also in subsection D, caused by a hurricane occurrence. It's still, everything that we're bringing up here is still coming back to the question of whether causation is applicable. So subsection D, either you read it as being a windstorm caused by a hurricane occurrence or caused by a hurricane. The word caused by is still in there. So those questions still require some level of factual consideration. Whether the word hurricane occurrence is potentially an ambiguity or a sloppy drafting or something along those lines or not, we still believe that the causation element is something that has to be considered when deciding whether to apply the deductible. And I don't believe in this case that the public policy arguments are as dire as raised by appellant in this case.
So as far as public policy, I'm just curious about the operative law here. Is the contention that we are obligated to consider public policy or that we are permitted to consider public policy? Because in the standard of review sections of the briefing that I recall, it talks about that it's the language of the policy that controls, right? And I understand that, you each have your separate arguments about public policy, but could you unpack for me the place that public policy should have in our analysis of this question?
Yes, Your Honor. So the application of public policy, in our opinion, should not really be considered when construing the language of this policy because, again, every carrier has the ability to write their policies as they see fit. So as far as the application of public policy to the wider reaching effects on the state, it would appear that this policy itself stands alone. So this court's interpretation of this policy perhaps will affect all of the policies that were written in this way by this insurance carrier, but it's not going to be a question of whether the entire state is suffering a change in position on this because it's really dependent on the policy language itself rather than a statewide issue. If the statute had been written in such a way that all of the policies had to be exactly the same and all of the policies were written the same and we had this issue coming up in every single situation, perhaps there would be a bigger issue. But in our opinion, public policy is not a very important consideration when it comes down to specific statutory and policy interpretation in this case.
So you would concede that the legislature has authority to set public policy in this domain and could potentially require policies to incorporate certain kinds of language, perhaps even language that would very clearly say that any loss that happens during a hurricane is subject to a hurricane deductible, but simply that the statute does not so provide. Is that an accurate understanding of your position?
Yes, Your Honor. I think that's an accurate explanation of what we're saying here. The QBE case that was raised in the appellant's brief that discusses, it's very briefly raised as application of legislative efforts in property insurance, but it's QBE Insurance Corporation versus Chalfont Condo Apartment Association Incorporated. That's a case that considers a separate section of the statute that applies something that's mandatory in policies. It's a section that must be in every insurance policy that applies a hurricane deductible. It's, I believe, an 18-point font section that says a hurricane deductible applies to this policy. So the statute can apply a mandatory policy provision if it so chooses to do so. Otherwise, the statute, if it's not applying a specific language that has to be included in the policy, it's not something that is mandatory under the statute. I believe that the statute even provides that the hurricane deductible sections of these insurance policies have to be approved by the Office of Insurance Regulations, so there's obviously some level of leeway between policies where the carriers can choose what type of coverage they're providing, how they apply the deductible, et cetera. And I think that's also applicable in that the language we're considering is defining the applicability of hurricane coverage. So that's an important thing in Florida, that there be available hurricane coverage. The hurricane deductible is a separate issue that the carriers can apply as they see fit based on their policy language. So the Moody case talks about a situation where the policy is slightly different. It tracks the language in a different way. So it's definitely a situation where the legislature could change the statute in the future to make a more uniform application of a hurricane deductible if that's what it decided to do. So there was a few other issues that I wanted to bring up, specifically, again, talking about the Moody case. We believe that that's a distinguishable case. It's a situation where hurricane coverage was being applied as opposed to a deductible, so it's a slightly different analysis, although the language is similar. That was a case where additional living expenses and the availability of them in the instance of a hurricane was being brought up. So that's a slightly separate issue than what we're talking about here. And although the Fourth District Court did not necessarily address causation directly, there was language in that holding specifically talking about how elements of the storm system were found to have caused the damage in question. So the case we're dealing with here is a separate situation where the storm system, based on the undisputed evidence that was presented, was gone from the state of Florida at the time of the damage. And so basically, to conclude our position here, again, causation, the most important consideration, the words caused by come up multiple times, both in the statute and the policy. And so by the language that's provided in this policy, it's important to consider the factual implications here. I don't personally believe that there are a lot of situations where there's evidence demonstrating that there's a completely separate storm that caused the damage. Usually, you have, when the storm is passing over and causing damage, that's usually that's not a question. So I believe that there are a few other cases in the pipeline that are addressing this issue, but these are limited to these cases that are before the court today and basically focused on this policy language that exists. I would imagine that the insurance company in this case can change the policy language in the future should a ruling come down that interprets it in a way that wasn't intended by the policy. So if there are no further questions, I will conclude my argument.
Thank you.
Thank you.
Counsel, you have a little shy of 5 minutes.
Thank you, Your Honor.
And Ms. Lalou, if you could begin just with an explanation of your take on the propriety of considering public policy arguments. If you can point us to a statute, a judicial decision, or other source of Florida law that instructs us the relevance that public policy should play when interpreting an insurance contract.
Absolutely, Your Honor. And so as the QBE court stated, that plaintiffs have noted, public policy is within the realm of the legislature. And this court's job, of course, and the trial court's job is to enforce and apply the language of the policy and the language of the statute. The plaintiffs don't dispute the temporal definition that is encompassed in the policy and the statute. That's step one of their analysis. They asked this court to replace, however, windstorm loss with this loose notion of a hurricane loss, and that is step two of their analysis, and that is not founded in the policy and the statute.
So, taking your definition of windstorm loss, I understood you to say earlier that your reading of windstorm loss is loss caused by a windstorm, right? So if we look at D sub 1, and I'm inserting that reading, in the event of the first loss caused by a windstorm caused by a single hurricane occurrence, right? So if we substitute those words, that's what the phrase is. How should we read that? And what is the meaning that we should take from the words when we substitute them with caused by a windstorm?
Right, and so the sentence begins, in the event of the first windstorm loss. So it has to be a windstorm loss. This is undisputably, both sides agree, this is a windstorm loss caused by a single hurricane occurrence. So again, this deductible is addressing a couple of things. It's addressing the notion that you can't keep hitting someone with a hurricane deductible multiple times in a year. So we have to define an occurrence as distinct from a subsequent occurrence. And so going back to Part B, hurricane described. And this is a unique thing. I think we just have to keep that in mind, right? And that's what the legislature had to contend with. That's what carriers had to contend with. And that's what the Office of Insurance Regulation had to contend with. This is not a lightning strike. This is a hurricane. A hurricane has a duration. Not all types of losses do, right? Not all types of losses hang around for hours and hours and then leave conditions behind. Not all threaten to wreak havoc on the property insurance industry. And so the 72-hour period was implemented by the legislature and by carriers to prevent that crisis that the QBE court talked about. I do also want to address the notion that this is going to be rare. I don't think it is. So plaintiffs' counsel notes the issue of tornadoes in Moody, and don't worry about it because tornadoes are almost always caused by hurricanes. That ignores the evidence that the plaintiff presented to the trial court in this case. The expert here said hail isn't related to a hurricane, isn't caused by a hurricane, can't be. And that's plainly contrary to the language of the policy in the statute. I think the plaintiff thought that that 72-hour argument was a little more palatable, saying that that's not caused by a hurricane, again, in the colloquial sense, as opposed to the contractually and statutorily defined sense. But the evidence here is that hail can't be. And so the question is, are we going to plainly contravene the language of policy in cases to come? That's what this case opens up. As far as the statute goes, our position, of course, is that it's consistent. To the extent the court considers otherwise, we would absolutely, as we've argued, the statute is incorporated into the policy. It's part of the policy. It's part of what governs the parties. And so that absolutely applies. And again, they haven't disputed, they've never argued this is unambiguous. They agree with the temporal component. They argue there's another requirement that has to be shown here. And that additional requirement, causation by a hurricane as they define it, as opposed to how the policy defines it, hurricane occurrence encompasses hurricane. These are all defined terms, and they're all durationally defined. And for these reasons, Your Honor, we respectfully request that the court reverse and remand for entry of judgment for Florida Farm Bureau. Thank you.
Thank you. Thank you for your argument, and we are adjourned.